Ladies and gentlemen, boys and girls, listeners of all ages, welcome to another episode of All Things Litigation Funding. My name is Ted Farrell. We have a terrific guest coming in from the Sedona office of Archer Systems, Mr. Gary Goldberg. Gary, how are you? First, tell everyone where you are, and then maybe who you are, and then maybe we'll have a little chat. How's that sound?
That sounds great, Ted. Thank you for having me on. It's a real honor. I'm in Sedona, Arizona right now. It's my first visit to Sedona, and flew into Flagstaff and made the trip up here on Highway 89 today, which is one of the renowned highways, I guess, in the country for some great views, and took those in. And now I'm hopefully not going to get drowned out by the cicadas that are in the background here, but right near Oak Creek, so there's a lot of wildlife, a lot of greenery. It's really beautiful. And for those of you listening or watching that don't know me, my name is Gary Goldberg. I'm the Executive Vice President of Archer, and we are a large administration and legal support firm that handles primarily mass torts, managing a variety of different processes and sub-processes from the very beginning and inception of mass torts all the way through the final dollars distributed, and that includes to litigation funders. So I'm sure we'll get into some of the details, but that's a quick high overview.
All right. Well, I really appreciate that. So, spoiler alert, Gary is not an attorney. Spoiler alert number 2, he is not a litigation funder. Spoiler alert number 3, he is not a Russian or Chinese spy using litigation funding to commit espionage on our country. So you might ask, why is Gary here? Well, Gary is here today because I thought it was very important for people to understand, where does all this money go in these mass torts and how does it get there? And it gets there through something called the lien resolution process. So Gary, at a really just high level, when a case settles, what does it mean for there to be? People can sort of guess what lien resolution means, but I'm just interested to just say sort of, what all goes into this. What happens? You read about these big settlements, but how do people actually get paid?
Well, Ted, you actually have me thinking about being reborn as a Chinese spy. That actually sounds pretty exciting, unless I might already be one, in which case I wouldn't discuss that with you here, Ted.
Or maybe double agent, I think would be good. Maybe a double agent would be good for you. That's right. Okay. Anyway.
Exactly. Okay. Well, I don't know what the tort recovery process is like in China, but I certainly know a bit about it here in the United States. And broadly speaking, lien resolution in personal injury litigation refers to the process of identifying and negotiating and resolving claims by third parties who have paid for a claimant's medical care and now have a legal right to be reimbursed from the settlement or judgment. Usually that third party is a health insurer. That could be a private insurance plan, a kind of joint public-private type of plan like a Medicare Part C plan. It can also be a government agency. So Medicare, Medicaid, the VA, TRICARE, FEBA, any of these programs that pay for individuals' medical care, outside of the litigation context, could all conceivably have a right of recovery against somebody's settlement or judgment.
Okay, so I want to pause there because it's really important.
The way looks in practice, because
I
think it'd be good to give a practical example, is you get injured, right? It could be as a pedestrian in an auto accident, it could be as a passenger in an auto accident, but in the context of mass torts, we often see scenarios where someone is injured by a defective product, an allegedly defective drug, maybe it's exposure to some sort of toxic substance. And, let's look at a situation where, somebody has a hip implant, right? And that hip implant fails. They want to just go get their hip fixed. So they go see an orthopedic surgeon and they get all their scans, and it's determined that that hip implant needs to be replaced. They have to undergo a revision surgery. They undergo the revision surgery, they go through physical therapy and the recovery process, and somewhere down the line, they may be exposed to the news via legal advertising or other means that, hey, a lot of other people were experiencing this too. A lot of other people had this device in their body and it was failing, and there might be something wrong with the product, and lawyers are pursuing litigation or potentially investigating litigation against the manufacturer or distributors of that device. So that recovery process, that revision surgery
was not free. It was not free. That's right.
That's right. Pay for it. So, in a hip implant scenario, that might be an older individual who's on Medicare, right? Or could be somebody who has private health coverage or any type of health coverage. Somebody is paying for that. And so a hip revision, even at insurance rates, could cost tens of thousands of dollars, right? Even into the hundreds of thousands of dollars, depending on complications. And at that point in time, there is no recourse. There is no recovery against another third party. But once that exists and the claimant has a settlement or a judgment against a tortfeasor, then that triggers either a statutory lien right or a contractual subrogation action from the health plan that says, hey, wait a second, you're telling me somebody else, another entity, this tortfeasor, was responsible for you getting injured, and thus us, either representing the taxpayers, the government, or a private plan? Well, we're going to recover now. We're going to assert a lien against your settlement, and that's where our whole process as a lien administrator kicks in, and essentially we try to figure out how to effectively and efficiently resolve these liens for large litigations.
Okay, so let's say this. So I'm going to imagine, and this is wholly untrue of you, but I just want you to play the part here, right? Imagine you're a cruel person that doesn't care about individual pain or individual suffering, but you do care about the solvency of things like rural hospitals, or the solvency of Medicare, or the solvency of Medicaid. Talk a little, because I don't ever read, all I ever read about mass torts is the only people who get money are lawyers. Are you telling me that that when a tortfeasor has to take responsibility, that money just doesn't go to lawyers' pockets? You're telling me that like the government gets money back as well for charges that it incurred for all this activity?
That's correct, Ted. So let's take Medicare, for example. Medicare.
That's a big one. That's one of the biggies. That's a big one. I've heard of that one. Yep, that's a biggie.
It's probably the simplest one to understand, right? In the context of what we're discussing, the federal government has made an outlay of capital to cover your medical care, and when this is done over and over and over and over in the context of mass torts, where taxpayers have had to pay for medical care to cover the negligence or alleged negligence of a third party, the aggregate amount of the potential recovery that they have can be quite significant. So you're talking about mass torts that may settle in the billions of dollars, and Medicare alone may have hundreds of millions of dollars, or potentially billions of dollars with a B, of recoveries to make against those lawsuits. It's not an insignificant amount of money. So, we even looked at an analysis of just our own projects, right? Mm-hmm. We're not the only player. We may be the biggest company in the lien resolution business, but just out of the funds that we manage, not even all the liens that we negotiate, over the past 4.5 years, we've paid governments and health plans nearly $1.6 billion back, and that's after negotiating the liens down by about 90 to 95%.
Right. So basically, what I think I hear you saying is, and tell me if I'm wrong, that in a large mass tort, so then when I say large, let's put it this way, one where thousands or tens of thousands have, taken, had a defective device put in them, had to get them taken out. So you got to get a surgery, you have to recover, all that stuff. So you're saying that actually like multi-billions of dollars have likely been spent providing Medicare, providing medical care for those victims, and at least some of that comes back out of the settlement.
That's correct. Yeah, that's a fair assumption. And in a day and age where state Medicaid agencies are under a lot of financial pressure right now, where people are talking about the solvency of Medicare over the long term and how we're going to support that. These are not insignificant or unimportant dollars. Every dollar certainly counts to go back in the pot.
Okay, so then logically, you're telling me that I can take a stance here. I can hate lawyers, but still find good in the mass tort system because the government gets paid back. Am I allowed to do that then? That's what you're telling me? You're giving me license here?
Yeah, that is accurate. Yeah.
Well, Gary, that permission is huge. You've opened up a whole new world for me to take a position. But look, I'm obviously joking about this and being, a little bit obnoxious about it. But I think what is lost here is that, there's certainly this sort of idea that's propagated in the mass tort system that the only beneficiaries are either lawyers or potentially the people who fund the lawyers. And I think that, from you sitting at Archer where the money actually goes out, the public, John Q and Jane Q taxpayer, as well as Medicare and Medicaid are recovering as well for the care they had to give due to the actions of these people. And I just think that, we talk about regulations and tort reform and funding and all these things, I think it's important that people at least really understand where the money goes to make sort of, good choices on, what we do going forward.
Yeah. I don't know if I've ever seen a scenario where everybody involved, certainly on the plaintiff side or on the third-party lien holder side, says, yeah, there's definitely enough money here. There's definitely enough money to fully compensate this individual for their injuries and their pain and suffering, and that there's enough money here to pay dollar for dollar back to the plans and agencies everything that they spent. The nature of mass torts and the reason why they settle in aggregate the way that they do is because there's a big compromise to be made, right? So even in this situation where plans are getting paid back, they're taking a haircut, the claimant's taking a haircut, and the lawyers are fiercely advocating, of course, on behalf of their clients. But everybody is trying to get to a position where there's some sort of equitable recovery. And a lot of these mass torts that have a participation threshold of 96 and 97%, right? And the lawyers have to do a lot of work to convince the clients that this is the best path to resolving their case. And that's not easy, especially when you have third-party lien holders involved, but that is the reality of mass torts.
Yeah, and I think just when, in these large things where there's been widespread injury over sometimes decades, there's not enough money. But I think it's sort of it's a myth that there's some sort of windfall when the math sort of doesn't work out that way. So I want to move on to something else here, because there's also sort of this idea that, all the claims are frivolous. And of course, the day any case is filed, the defendant says the whole thing is frivolous. It's all made up. And then they, of course, go through the discovery. They get the emails and they say, oops, sorry, we shouldn't have done this or that. But I guess I want to ask you, tell me and tell listeners, what's a settlement grid? And then I want to talk about the work you all do on settlement grids. But tell sort of like the listeners, what's a settlement grid in a mass tort?
Yeah, so a settlement grid is a scoring system, and there's a lot of different ways to come up with a scoring system for different injuries. Uh, Sometimes the settlement grid is agreed upon between the parties. Sometimes there's a special master, neutral party that comes in. Sometimes it's a dance between the parties, a special master, and a claims administrator. But it's most often applied in a classic sense in a situation where a case has settled, right? So a case is settled as a global settlement, or what we call a docket settlement. So a specific law firm has a tranche of cases and they settle those. But sometimes there's globals where every case out there that qualifies is now settled, and there's not going to be new cases coming in. And there's combinations that are somewhere in between there. But let's say you have $100 million and you have to figure out how to divide $100 million up in a way that accurately reflects the underlying injuries and qualification criteria. You have to come up with some sort of scoring system, a rubric, and that's essentially what a settlement grid is. So, for example, you may have a settlement grid that establishes a baseline value that says certain injury classifications are worth X, Y, or Z, depending on severity, depending on length of exposure, depending on any number of different factors. Maybe there's a component that says, like, do you have establishing records for certain subsets of injuries or not? There's literally unlimited factors that can go into the settlement grid. But let's say in a simple scenario, there's 3 tiers of injury, the highest tier being death, and maybe a middle tier being stroke, and the lower tier being deep vein thrombosis, right? This is a circulatory type of injury. And if you meet the criteria for a certain category, you get slotted into that category and you get an amount of money that corresponds according to that settlement grid. Sometimes there are enhancements. Okay, you had deep vein thrombosis, but you also had certain other afflictions that might bump your score up a little bit. And you're assigned some extra dollars or some extra points that correspond to dollars. Or maybe there's deductions for things like, comorbidities, confounders, right? Were you a smoker? Did you have other, risk factors that would lower what you're entitled to? It's essentially on a macro scale, what like a jury might do for a specific individual in evaluating their case, but you have to come up with something that you can apply uniformly across a large population of people.
Right.
So that's, and sometimes the defense is really involved in coming up with the settlement grid. Sometimes they say, hey, that's for you to figure out. We're writing a check.
Right. And so, but I think there's a couple things here. So first, none of this is a game. I mean, we're talking about suffering, up to, in fact, like death. So, when talking about, these mass torts, and this gets bandied about, like we're talking about like an actual human toll. But I think what has always interested me, and especially I learn more about it, the amount of detail that any individual has to come up with in order to qualify for interest. So, for example, if I just called up and said, "Oh, I did this and I did that, and I have this affliction," talk about the level of detail with medical records. Sometimes you have the SKU number of the device. Like, what does it actually take for a claimant to get paid? And the reason I'm saying this is, people can just use the word frivolous and it's meaningless, right? I think the word frivolous is just sort of doesn't really have any meaning in this context. It's just sort of like a catch-all. But talk about the level of detail that an individual claimant's file would need in order to actually secure a settlement, which, by the way, is a fraction of what they would deserve if there weren't tens of thousands just like them. So there's not enough to go around.
Right. No, it's a great question. So, as a general statement, the amount of information required to substantiate one's claim can and does differ from tort to tort.
Tort to
Right?
tort, of
And
course.
it even,
Right. Yeah.
you know, it's
Right.
even different among like different classifications of civil torts. So for example, if you have a data breach case, there's a different standard that is going to be used. There's a different expectation than you would have in an injury scenario where someone is going to ultimately have to prove two basic things: that they were exposed to whatever the defendant's product was, right? So, were you exposed to Roundup? Did you take a particular drug? Did you ingest something? Did a particular device get planted in your body? So you got to prove that you actually have what you say you have. Right. And then the other element, of course, is damages. To what extent were you injured, and has that been substantiated? So the exposure piece can vary from pretty widely in mass torts, right? If you look at a case like Zantac or even Roundup, where this is an over-the-counter drug.
These are retail products anyone could buy, right? Anyone could buy, right?
Yeah, it's not showing up in your insurance history, your prescription history. There's not a medical record per se.
Well, let's talk like a medical device. So what would you have to show in a medical device? Because I think this is where
so in a medical
would be
device
shocked at the level of detail. Yeah.
Yeah, like when 99% of people, when they go in and get a medical device implanted, they're not looking at who like the specific manufacturer is and who the sub entity is. They just know they're getting fixed, right?
Right.
And maybe people become more diligent about that. But when you have a lawsuit, you've obviously got to prove that company's device, and even
the model,
like,
not even just the maker.
It might be a specific batch, right? Certain serial numbers.
Right.
Well, you have to go into the medical records to substantiate that you have that product in your body. And so in a device case, it's a pretty binary deal, right?
What I'm trying to get at is, what are the chances that someone is just going to make up an injury in a medical device case and get paid?
I mean,
pretty low, right?
Slim to none. I mean, barring like some pretty creative fraud,
right?
It's not going to.
In other words, I think people. I think people would be shocked that one of the things they're looking for is, I want to see the SKU number. I want to see the SKU number from the X-ray of that one, because it doesn't matter that I'm the manufacturer. It had to be that one, because I think that again, this idea of the frivolous claim is really meant to get people to think, it's just fake people coming out of the woodwork. And in these cases, when you're talking about, you have to show injury, you have to show your medical treatment and all that kind of stuff. You don't get paid just by calling an 800 number and saying something. You have to prove it. And I think that, that's just an important thing, I think, for people to understand, is the reality of how these things go.
Yeah. There's not a tap you just turn on to go get your recovery. And not to mention, I believe that the vast majority of lawyers want to act ethically, right? And they want to represent their clients in good faith. And it is not conducive to the health of the ecosystem, and it's not helpful to seriously injured people to push forward a bunch of bogus cases. Like they're going to fall flat on their face. They're going to look terrible in front of a judge. They may lose their license. There's business risk involved, because you have carrying costs associated with these cases. You have administration and overhead associated with keeping clients retained and moving their cases along. So it's just not something we see a whole lot, Ted.
Right. Okay. And then sort of the last thing, because I think this is sort of interesting. So there's talk about, when there's litigation funding, sometimes the client only gets this percentage of the award. And I think, and again, you tell me if I'm wrong. Of course, I have the power to edit. So if I'm wrong, maybe I'll edit this out. So that'll be the big tester, right?
Here comes the beep.
Right, exactly. So no, but in a mass tort, generally the ones that I see, typically an injured person would go to a law firm, and the law firm would say, we'll represent you and we'll take a contingent fee, and that will vary state by state, but maybe 30 to 40%, right? So the law firm gets so when the lien gets resolved, so in that kind of case where the law firm has borrowed, right? Unless I'm wrong, the funder, to the extent there's any money going to a funder, that is coming from the law firm's contingent fee. The funder is not touching the claim holder's fee. Is that right?
That's correct, with the exception of the funder lent directly to that plaintiff.
Right. If that plaintiff took a consumer loan, but assuming that, and that's different kind of lending, and we can talk about that another day. But
That's right.
For the typical case where, I had the metal on metal hip implant, I had to get a revision surgery, and law firm, you're going to represent me on a 30% contingency. If that law firm self-funds, they're getting 30%. If they have recourse bank money, they're getting 30%. If they have litigation funding. But I think that's important, at least in the mass tort world, that there's no contractual privity with generally the claim holders. And so if you want to talk about cases where there's a relationship between the funder and the claim holder and what that might mean, that's typically not the case in these large mass torts. Is that right?
Right. That's right.
Okay. And so when that money sort of comes through the piping, that plaintiff piece just goes, and then everybody else can chop up the rest. Is that sort of the deal?
Yeah. Listen, I think we can boil it down another way, which is Archer has resolved and distributed tens of billions of dollars of mass torts, even over the last 5 years, let's call it.
Mm-hmm.
And the role of the litigation funder does not play into our calculus as an administrator, does not play into our decision making or the way that we apply methodologies when money goes to plaintiffs. So I think I'm just trying to reinforce, what you're saying through the practical reality of things. It is up to the law firm to pay off their loans, and it's not coming out of the plaintiff's portion. So
I'll just do that. Let's say a law firm was having a squabble with how much they owed their funder, and the funder's in a fight. That doesn't affect at all what the plaintiff gets.
No, I mean, there's their answer is no, necessary, but no, it doesn't directly affect the plaintiffs.
Right. Yeah. So in other words, and again, I'm sort of beating a dead horse here, but I guess that's, it's one of the great things about me. I just repeat it, but I think it's important for people to know, if you enter into a contingent fee with a law firm and you agree that the firm gets X and you get Y, no matter how they're funding it, you get what you get, and it's between them and their funders.
That's right.
Okay.
That's right.
Well, I'm going to ask you one more, and then I'm going to let you go. What do you think is sort of a misconception about mass torts that you've seen now that you're sort of really behind the scenes and seeing how this works? I think people generally don't like lawsuits generally. I think that's just sort of I think that's just an opinion that people hold that has been sort of a long-standing thing. What do you think is maybe a misconception, and maybe a misconception you had before you were involved in seeing how this all really works and where it all goes?
Yeah. So we could definitely record another podcast on dispelling myths, but I think one of the big ones is the idea that mass torts are just some big trough that a bunch of pigs can come eat for free at, right? And that it's just a bunch of advertising and a bunch of aggregation, and then eventually these things settle and everyone's getting rich. It's not really how it works in practice, right? And I think that the anybody who takes that approach on the plaintiff side is in for a very expensive and rude awakening, because that is just not the way it works. There are very smart, very sophisticated people working for defendants and representing their interests, and they're not just writing checks because it feels good to write checks, right? You have to have a case, you have to do your work on the plaintiff side, you got to prove and vet these cases, and you have to be smart about how you litigate them. It is not just an open tap.
Got it. Okay. Well, Gary, you are the man. Thank you for joining us. And I hear they have a terrific salmon salad out there in Sedona. So I hope you get a chance to enjoy it. I'll talk to you soon, buddy. Thanks.
I'll talk to my spy contacts, see if I can get one. Thanks, Ted.
See ya.
Take care.